who is a senior advocate. And finally, we will have a response on the panel discussion by Justice Raveendran, who is also the author of the book. And we will end the webinar by a vote of thanks. I would now like to call upon Mr. Smith Malik, who is the director of EBC, to give his welcome address.
My Lord, Justice N.V. Ramana, the Chief Justice of India, my Lord Chief Justice Venkatachaliah, my Lord Chief Justice R.C. Lahoti, my Lord Justice B.N. Srikrishna, my Lord Justice R.V. Raveendran. It is my privilege and honor to welcome such distinguished personalities to this function today. None of them require an introduction. Chief Justice of India, and his judgment in Anuradha Bhasin upheld the freedom of speech and expression through the medium of internet, holding that internet shutdown must satisfy necessity and proportionality. Venkatachaliah, called the Bhishma Pitama of the Indian legal system, continues even at his age of 94 years plus to influence our thinking and development of legal thought. Even a 10-minute interaction with him allows a person to explains the nature of proceedings and relief under public interest litigation. In Antale, he observed that courts are as much human institutions as any other and share all human susceptibilities to error. Chief Justice Lahoti is one of the most respected Chief Justices India's had, and the thought are unparalleled. His judgment in Dawi Bora on the doctrine of precedents, concept of stare decisis, and per incuriam judgments is seminal and still holds. Was one of the most erudite judges on the Supreme Court bench, and his contributions did not stop even when he stepped down from the bench. He has been part of very law in fields as diverse as the Mumbai riots, finance and business, financial irregularities, data protection, and the use of technology and artificial intelligence in the field of law. He was on the bench with Chief Justice Lahoti in the Dawoodi Bora case. His own judgment in state of Karnataka versus All India Manufacturers Organization in 2006 was an important case on the practice and procedure to be followed in case of PILs. Apart from laying down the law on res judicata in case of PILs, it also clarified that an instrumentality of state. He also imposed exemplary costs on the state government for 5 lakhs for frivolous arguments. Justice Raveendran, I can safely say, has been one of the finest civil and commercial judges to have appointed to the Supreme Court. Economic Transport Organization in 2010, where he expounds the concept of subrogation and assignment, is seminal. Many of the cases decided by him on arbitration remain the leading cases on that subject. He has many articles to his credit, and of course, today we celebrate the release of his book. Shri Arvind Datar, senior advocate, has over a period of his practice not only mastered constitutional law and tax laws, but alongside has been involved in so many projects relating to access to justice, use of technology in the law, and others. Interestingly, in Madras Bar Association case, where the constitutionality of was argued by Mr. Datar, and the unanimous judgment of the court was delivered by Justice Raveendran. We are privileged to have all of you with us today. In this new world of technology and artificial intelligence, which allows for self-publishing, publishing on blogs, etc., the question is there still a role left for publishers? At EBC, as we celebrate 75 years of being around, what we have learned is to understand what the legal profession requires and what our role can be in fulfilling that requirement. To us, we believe that our role is to bridge the gap between legal information and knowledge and those who consume that legal information and knowledge. To be effective in our role, it is important that materials or content that we produce is authentic, accurate, and reliable. Also, we have continued to innovate over the years to keep ourselves relevant. In 1969, when Mr. Suren Malik graduated from the Delhi University, Having studied by the newly introduced case method, he realized there was a need for faster reporting of Supreme Court judgments. Thus came about the innovation of Supreme Court cases. As you are all aware, that there can be no second edition of a law report, and it must be got right the first time. Prompt, accurate, and complete has been our philosophy, which we've adhered to since then, and we understand and recognize our responsibility that the honorable judges and the bar repose on Supreme Court cases. As soon as publishing shifted to desktop publishing, we at EBC adopted it and shifted our publishing from hand-composed type to software-designed typeset to digital printing, the latest innovation in the field. Print on demand has gotten to the publishing industry before laser printers printed aircraft parts and human hearts. EBC was amongst the first to introduce a legal research database on CD-ROM in 1996, which was less than 650 MB then, and now the SEC Online Web Edition has over 10 terabytes of data, 4 million documents covering over 250 jurisdictions. Even though we believe that the printed book is here to stay, yet for the tech-savvy, EBC's EBC Reader platform is ready and has over 350 books, and we add new books to it every day. The SEC Online blog, on which we report happenings in court, law schools, and the like, now has over 1 million views and 4.5 lakh visitors every month. To bridge the gap between what is being taught in law schools and what are the skills and knowledge required to be a successful legal professional, EBC has launched its latest innovation, EBC Learning. It has been a wonderful experience working with Justice Raveendran on his book. We thank him for the opportunity. Judges, for those in government and public service, and the common man too. It is sincerely hoped that these lessons are read, understood, and imbibed, and it helps strengthen the rule of law and values and traditions that India stands for. Once again, I welcome all of you today, and we look forward to a fantastic session with Mr. Datar and the panelists.
Thank you, sir, for your insightful words. Next, I would like to invite Chief Justice RAMANA to release the book by holding it up in his hands. And I would also like to request all the panelists to please hold up the book in your hands so as to commemorate this occasion. Thank you, Justices. It is indeed a momentous occasion for all of us to have this book released in the presence of so many eminent personalities. Thank you all. Next, I would like to call upon Justice.
Wait 1 minute, please wait.
Okay.
Chief Justice, do it.
Okay, sorry. Thank you, sir.
May I request all of you to hold the book up again, please?
Yes, sir, please hold the book up again. We will take a screenshot of this.
Yeah.
Thank you so much.
Thank you.
Next, I would like to call upon Justice Venkatachaliah ji, former Chief Justice of India, to say a few words on this occasion.
Honorable Justice RAMANA, Chief Justice of India, Justice Lahoti, Sri Arvind Datar, Justice Srikrishna, Justice Raveendran, Sri Sumit Malik, Mas Nover Pateja, all the distinguished panelists, ladies and gentlemen. Justice Raveendran's vast experience and legal erudition as a lawyer and a judge inform these pages of this book. There is a fund of information on every topic dealt with by him in this eminently readable book. The most distinguished, significant aspect of his judicial personality is that despite his great familiarity with legal theory and legal principles, he brings to bear upon the subject a pragmatic approach of pragmatic solution. The ideal justice is a never receding horizon, and as a concept is an invitation to a debate on the irresolvable issues of man's eternal quest and to conflicting social philosophies. Providing practical solutions to the conflicts of men is the primary concern of the art and science of adjudication. I may recall what Roskill said in a very eminently readable article. Law lords, reformers are reactionaries. He said, much of the common law and virtually all the criminal law is a blunt instrument by means of which human beings are governed and subject to which they are required to live. And blunt instruments are rarely perfect, intellectually or otherwise. By definition, they operate bluntly and not sharply. Unquote. Raveendran's judicial philosophy accords broadly with this philosophy. The constant problem in constitutional adjudication is one single continuing theme: how to steer the living stream of law between the dangers of rigidity on one hand and the dangers of formlessness on the other. The Canadian idea of dialogue in constitutional adjudications is a great experiment. Personally, I have great regard for Justice Raveendran. In his article, Musings and Management, he reveals a side of his personality, being tough and being gentle. He refers to Raymond Chandler's fictional detective Marlowe. And somebody asked him, how can you be so hard at the same time so gentle? He said, if I weren't hard, I would not be alive. If I weren't hard, I would not be alive. If I were not ever gentle, I would not deserve to live. If I were not gentle, I wouldn't deserve to live. If I were not hard, I would not be alive at all. This is the dilemma which every administrator, every judge will face sometime or the other in his life. This book is a beautiful book. I have written a long foreword. I think that is the 101st foreword that I have written to books in my 30 years of retired life. Ladies and gentlemen, it's a beautiful occasion. Chief Justice RAMANA has honored us all by releasing this book. And I must congratulate Sumit Malik for the great contribution they are providing to the spread of legal literacy and promoting good books and good literature and law. Today, the scenario is totally different thanks to publishers, imaginative publishers like Sumit Malik and others. Thank you very much for inviting me. It's an honor to be with you today. I cherish it. Thank you.
Thank you, Justice, for your enlightening words. Next, I would like to call upon Justice Lahoti, former Chief Justice of India. Welcome, sir. We would be honored to hear a few words from you on this occasion.
Thank you, Nilofer. I deem it a matter of privilege to me to be participating in this function with the Honorable the Chief Justice of India as the chief guest and the Bhishma Pitame of the judiciary, Honorable Justice Venkatachaliah, and sitting with him as a panelist. I admit it with a matter of pride and pleasure that whenever I get an opportunity of meeting Justice Venkatachaliah, I have been nothing short of touching his feet, and touching his feet has been a source of inspiration to me throughout. Brother Justice Raveendran, Justice Srikrishna, Senior Advocate Mr. Datar, Mr. Malik, and all your colleagues and all the audience participating in this beautiful function, which is sober and its own implications. I would confine myself on this occasion to a word about my esteemed brother, Justice Raveendran, and 2 words about the book. Justice R.V. Raveendran, RBR for short, as I know him, every judgment authored by him has been a specimen of accuracy, certainty, and exemplification. Today, I am a little amused to find the book compiling his writings by him having been given the title of Anomalies. It was somewhere in the year 2001 or 2002, late APJ Kalam, the then President of India, visited the Supreme Court on the request of Justice B.N. Kripal, the then Chief Justice of India. At the high tea, during informal discussions, I asked Kalam Sahib, what is your message to us, the judges of the Supreme Court? Quick was the response. Kalam Sahib said something like this: among 124 crore people of India, you are 24 judges of the Supreme Court. Can each one of you be a role model to the people of India? And then we all dispersed. Ever since then, I have been searching. Is there someone whom I can cite as a role model judge? And I found the answer in RBR. His first judicial quality is that he is a gentleman. He listens with patience, considers by conscience, answers wisely, holding the scales of justice even in perfect balance. He would not care for the aftermath, whether a judgment would please someone or would be criticized by anyone, much less whether applauded by the public. Sitting in the court, he never raised his voice, never lost balance, never exhorted, never made any comments, much less criticized anyone. He would not deliver sermons, neither by words of mouth nor by pen. He believed his duty was to judge the case, the facts of the case, and not to judge the persons implicated as parties in the case, which privilege belongs exclusively to the court. He would meet people, but maintaining a safe distance. I wish if he had the opportunity of dealing with more subjects and pronouncing his dicta thereon. I am happy that what he could not do as a judge is being done by him as a learned author. This book, Anomalies, has something for everyone belonging to fraternity of law and justice. The entrants of the legal profession, newly appointed judges, would find a lot to learn from the Anomalies. Even the seniors would find enough in the book to further improve themselves. A law professional, whether lawyer, a judge, an arbitrator, a mediator, a conciliator, would all have valuable tips to draw upon. The book shall be read and reread by all those who wish to be RBR. The Anomalies would go a long way to recreate, refresh, and restore the much needed judicial values. I would beseech my Lord, the Honorable Chief Justice of India, to have this book prescribed as a textbook in judicial academies, including National Judicial Academy, and question-answer sessions to be held on the subjects dealt with in the book. For this book is not just theory, it is practical wisdom related to law and justice. One thing which I can say with confidence about this book is that this book is, in this book, there is not a word, not a sentence which has not been practiced by RBR. Every chapter, nay, every page of the book is studied with jewels of wisdom. Recently, having come across some strange orders passed by some courts, I happened to ask RVR, are the fundamental rights not being stretched too much and too far, like a rubber band? The answer which he gave to me needs to be read by every judge dealing with fundamental rights issues. He said, the more we expand the fundamental rights, the more we dilute them. Such like books are precious gifts to the present and an intellectual legacy for the future generations. I, with these few words, place on record my admiration of the book, and I gratefully acknowledge RBR and EBC for making me available a copy of this book, which I have selectively read, but I may tell you, I can't afford to read the book. I shall have to study it. Thank you very much.
Thank you so much, sir. Your speech was extremely thought-provoking. Next, I would like to call upon Justice Srikrishna ji, former Judge, Supreme Court of India. Sir, please say a few words on the occasion of the book release.
Thank you. The Honorable Chief Justice, Justice Venkatachaliah, former CJI, Justice Lahoti, former CJI, Brother Raveendran, Mr. Datar, the team from EBC, Surendra Malik, Sumit Malik, Nilofer, and Bhumika. It's indeed a happy occasion for me, who has been virtually rendered a house prisoner for the last more than 12 months or 13 months, to be able to meet all my colleagues at one stroke. Now, a few words, and I mean really few, not more than 5-10 minutes, few words about the author and few words about the book. Now, the first time I came across Brother Raveendran was when some of his judgments in the Madhya Pradesh High Court came up in appeal before the Supreme Court. And I must say, I fell in love with them at first sight. Because having been used to all kinds of rubbish being written, this was really a very pleasant and a very happy occasion to read a judgment which not only made sense, but taught me exactly what the law was. Now, after that, when I was in the Supreme Court and I had almost come to the end of my tenure, I was pleasantly surprised when Raveendran walked in one day and said hello to me, and he had been appointed. I had a very short tenure of sitting with Justice Raveendran. That was really pleasant, short and sweet as it was. Several qualities that I noticed: that he was a very pleasant gentleman, both as a human being and as a judge. I did not find him ruffled by some of the very abusive and abrasive lawyers in the Supreme Court. He also had a good quality, namely meticulousness. Even though we could sometimes make short orders, he would take the trouble of reading the order thoroughly, making sure that all the I's were dotted and the T's were crossed, punctuation was right, capitalization was right, and finally the order did convey exactly what the court wanted to say. Whenever he wrote a judgment as a junior judge, I had no need to even read it a second time because I knew it would be dead right. And all that I had to do was say, like a Tathastu Brahmin, I agree and sign it. That is a goodness. Thereafter, he was a colleague on the committee which we headed for making changes in the arbitration law and institutionalization arbitration. And his contribution there was invaluable. Although, much to our chagrin, very few things were really accepted by the government, as usual. Finally, I'm happy that he's one of my co-arbitrators. In fact, I chose him to be the president of an international arbitration tribunal. He was a little reluctant, saying, how can I be your senior? I said, no, you are much more than what I am. You deserve to be the president. I'm sure that this will inspire younger generations of lawyers and judges. Now, 2-3 words about the books. What the gentleman is, the book reflects. Now, these anomalies of law is the result of his vast experience of law, both as a studious academician and as a practicing judge, of wherever he has found holes in the law, kinks in the law, oppressive points in the law, which he needs to highlight. He has highlighted them sufficiently for the benefit of the lay public, for the benefit of legal fraternity, including the judges, so that these pressure points, these irritations can be removed and justice rendered to the public at large. I very much appreciated his broad spectrum of dealing with the subjects, whether it be anomalies of the laws, corruption, then about administrative law, then his kind guidance to lawyers, counsel, junior judges, senior judges, how to write a judgment and what needs to be emphasized in a judgment. This is really indeed a classic textbook material, and I'm sure the Honorable Chief Justice will take up the suggestion made by Justice Lahoti and have it prescribed as a study material for youngsters to become good lawyers and better judges. Let us hope that you will have more and more judges like Justice Raveendran, and that we'll have more and more books written by him, and may the good Lord give him more power to his pen to produce this, and may also hope that EBC will have the honor of publishing more and more such books for the benefit of all and one. Thank you very much.
Thank you, Justice, for your insightful speech. Next, I would like to call upon Justice RAMANA, the Chief Justice of India, to address the virtual gathering. Welcome, sir.
Good morning to everybody. Honorable Justice M.N. Venkatachaliah, the Bhishma Pitamaha of Indian Judiciary, Honorable Justice R.C. Lahoti, Honorable Justice P.N. Srikrishna, Honorable Justice R.V. Raveendran, Honorable Justice B. Sudarshan Reddy, Senior Advocate Sri Arvind Datar, Sri Sumit Malik, my senior and colleagues from the bench and members of the bar, ladies and gentlemen. I am overwhelmed to be in the presence of the judicial grades of India. They have been extremely kind to me in my whole journey so far. Your blessings have brought me so far. Justice Venkatachaliah has been a role model for me since my student days. At this age of 94, he still remains as a powerhouse. It is humbling to be in the presence of these luminaries. I am free from stage fear, but today it is different. Standing before you stalwarts makes me a bit nervous. So I deem it a matter of great privilege to be part of this book release function for a number of reasons. My association with Justice Raveendran relates back to several years, and I am fortunate enough to have such close acquaintance with him. Today, I am running the risk of being called a biased judge by none other than Justice Raveendran. This is what happens when you speak frankly about a person who is your guide and inspiration. He is humility personified. I was left with very little choice when I agreed to be part of this event and speak about both the book and its author. Justice Raveendran's judicial wisdom needs no introduction, particularly to this august gathering. He is an amalgam of unwavering commitment to the rule of law, strong believer in the independence of the judiciary, having a deep sense of morality and scholarship par excellence. His tireless work towards reforming our judiciary has been critical in shaping our jurisprudence. He came from a humble background with no family pedigree in the profession, trained under Sri S.G. Sundaraswamy, a doyen of the Karnataka bar. Justice Raveendran has the ability to relate to people and issues around him. Justice Raveendran's judgments are of great value, not because they are replete with Western jurisprudence or rich in legal jargon, but because of their connect with today's Indian context and his people. Judgeship was never an office for him. He never tried or made an attempt to project himself as the savior of the judicial process. He continued to be humble and believed that the office which he held did not exist for himself. He discharged his duties with distinction and commitment to the people. He believed in the dictum, as Lord Denning said, I quote, that the best judge is one who is less known and seen in the media, unquote. He exemplifies all that is great about our institution. Like many of my colleagues, past and present, I have always been a great admirer of his judgments, which are of simple language, intelligible, and clear to the common man. Through his judgments, he has set a standard of excellence, which demonstrates that law can be a force in society to bring out the best in the community and make it a better place to live. Let me turn to the book now. The book titled Anomalies in Justice is an attempt to explain to the layman that the law and the legal system is still evolving and that it requires more critical thinking to resolve issues which have persisted in the system for a long time. Through this book, Justice Raveendran undertakes to explain in simple terms various deficiencies in the law which require to be overcome so the common man does not lose faith in the judiciary and the legal system. In the foreword, Justice Venkatachaliah wrote that the book preempts the need for any extraneous foreword, but his admiration for Justice Raveendran compelled him not to deny his opportunity to record his tribute to this eminent work. These words speaks volumes about the books as well as the author. Before I opened the book, I thought I will read the entire book at some other point of time, leisurely due to the paucity of time. But the moment I started reading the book, I could not resist myself from completing it. The narration is captivating. The book is divided into two parts. The first part is addressed to the common man along with judges and lawyers. The second part is specifically addressed to lawyers and judges. The second part is specialized on its outlook and addresses certain complicated issues which have subsisted for decades. This book covers procedural as well as substantive law relating to civil procedure, electoral reforms, and the alternative dispute resolution mechanism. The treatment given in this book is scholarly with a mix of both academic and practical knowledge. It caters to both legal professionals as well as the academicians. The first chapter sets the tone for the entire book, wherein Justice Raveendran identifies certain existing anomalies in the law. There is no doubt that Indian law is filed with old legislations enacted during the British rule, which have lost their significance in the contemporary India. One such example, which he highlights, relates to the fines under the IPC, which have not been amended since 1860. He concludes the chapter by noting that there are many such examples which need to be considered by both a vigilant bar and the bench. One aspect which caught my attention is the part addressing the ADR mechanism in India. Justice Raveendran has years of experience in that field. He has the distinction of setting major contentious arbitration across India as well as in the other countries. Recently, in the case of Vidyadroliya, I had an occasion to deal with an area of arbitration which has troubled the Indian courts since the enactment of the Arbitration Act 1996. Initially, when the court started interpreting the 1996 enactment, it was seen as an intervention by courts at every step of the arbitral process. Such an approach was detrimental not only to the autonomy of the parties, but was also a reason for increasing judicial backlog. It was Justice Raveendran who, for the first time in the case of Bhujalan, recognized such excessive interventions as being detrimental to an arbitration-friendly image of India. It is only after his judgment that the Supreme Court and other high courts followed the trend to interpret the law in an arbitration-friendly manner. Ultimately, the noble intentions laid down in Bhujalan were fully realized through the recent amendments to the Arbitration Act and subsequent judicial interpretations. If I may say so, Justice Raveendran played a significant role through his judicial pronouncements in helping India realize its true potential in the liberalized economic environment. In the final chapter, Justice Raveendran again navigates through various issues affecting arbitration practices in India. From the lack of professional vigor to delays, the book addresses these concerns in great deal, which must be looked into by all stakeholders so as to achieve the full potential of arbitration in India. The author lastly concludes that an efficient arbitration system in India will not only strengthen trade and commerce in India, but also increases the confidence of the international community in India's dispute resolution process. The forethought of Justice Raveendran to make India arbitration friendly, which was against the established precedents at that time, is commendable. His efforts had the desired impact of enhanced ease of doing business in the country and tremendously cutting down in litigation time. The general distrust among the business community and regarding litigation was adequately addressed through these various judgments of him. Justice Raveendran's judicial capabilities is known to everyone. I have no hesitation in describing Justice Raveendran as one of the legends who have increased the prestige of the Supreme Court of India. Raveendran increased the public faith in the judicial process through his airtight judgments. Even after concluding his service as a judge of the highest court, he continues to be passionate of serving the public cause. This one volume speaks volumes about his lifelong efforts for working towards public interest. For me, it is a great honor to be considered worthy of releasing this beautiful book, which brilliantly radiates the wisdom of Justice Raveendran. I congratulate Justice Raveendran for coming out with this book, which is the need of the hour. I urge him to write more diverse topics of his expertise and share his immense knowledge with the world. Before I conclude, I wish I share a message that he sent at the time of my appointment as the Chief Justice of India. I quote, "Dear Justice Ramana, congrats. Best wishes and blessings. These are difficult days, challenging days, testing days. Being a Chief Justice requires courage to act, commitment to the cause of justice, concern for the common man, tact to deal with and obtain the cooperation of the brother judges in addition to the qualities expected of a judge. You possess all of them in abundance. Let the Almighty lead you to a purposeful, meaningful, and successful tenure." Unquote. I feel that this message is indeed the roadmap for my journey as the Chief Justice of India. I shall treasure this message forever. I wish him good health and all best for all his future endeavors. I congratulate the publishers to publishing this book. Thank you everyone.
Thank you, Justice. We are indeed privileged to have you here. And on a lighter note, we are also happy to see you in blue, which was the informal dress code of today, which we had decided. Thank you, sir. Thank you, sir. Next, we will have, I would like to call upon Mr. Arvind Datar to begin the panel discussion. Welcome, sir.
My Lord, Honorable Chief Justice of India, Justice Venkatachaliah, former Chief Justice of India, Justice Lahoti, former Chief Justice of India, Justice Srikrishna, and Justice Raveendran. It is indeed a great privilege for me to be asked to be the moderator of this session. It is, as Chief Justice RAMANA mentioned, it's a rare honor to be on a panel of so many eminent jurists at one place. As a student of law, I still remember the dissenting opinion of Justice Venkatachaliah in the Antule case. I remember so many landmark judgments of Justice Lahoti, Justice Srikrishna, and Justice Raveendran, which on a personal note, I may say that he really set the trend for the tribunal series of tribunal judgments after we appeared before him in 2010. It's a great privilege. As Justice Ramana said and other speakers have said, this is indeed a great book. And I'm not saying it for the sake of just saying it, but this book really deserves to be studied and digested.
Before you start this
panel, yes.
Further discussions, I will be present for entire discussion which I watch. I am on the screen, but I don't want to express anything. But I will really all your views, and I will note down that much I want to tell you. Please.
It is a great privilege that you're able to sit through. And of course, what we have done is, because there's only time, another 35 minutes are left. So
it's okay. For us, me, there is no time limit. So if you have a time limit for it, it's for you. But I will sit sometime, no problem. I will sit completely.
Yes.
Because
thank you, sir.
It's a very rare opportunity where you get stalwarts like Venkatachaliah, Lahoti, and Srikrishna, Justice Reddy, Raveendran, you. All of you are great people. I must listen, all of you.
For me, including my name, is a really humbling experience. I've seen all these eminent people. But now what we decided, sir, is that we will have a panel discussion. And we thought that the book has covered so many topics. In fact, as you mentioned, anomalies in law and justice, Justice Raveendran has analyzed 15 anomalies in law and justice. So it will be difficult to take all of them. So we decided as a panel to take up 3 issues. One is delays in disposal of cases, which is a perennial problem and it has to be addressed sooner or later. Second is technology and law. And lastly, the issue of public interest litigation. So we thought that we'll take up these 3 topics and then discuss it, get the views of everybody. I will start with this issue of delay in disposal. Recently in the Lok Prairie judgment, when the issue came up about appointing additional judges under Article 224A, we had the occasion for various high courts to get into the data. And I must say that the National Judicial Grid data is an outstanding website giving extensive and very detailed data. Out of the 50-odd lakh cases pending in different high courts, we found that 5 high courts have more than 53% of the arrears. Similarly, in the subordinate judiciary, 5 high courts have more than 54% of the arrears. So the arrears are concentrated in certain areas which are required to be addressed. As Justice Lahoti suggested, the problem of delay is separate in the subordinate judiciary. There are different reasons. It is also different in the high courts and the Supreme Court. Fortunately, Supreme Court, the problem is not so serious. As Justice Lahoti mentioned, the areas have been brought down to about 60,000-70,000 cases as compared to a vast number pending earlier. Now, sir, in the context of delay, I would first like to request Justice Lahoti to, one of the questions which has come up when I broach this topic with other members of the bar and other judges, retired judges. One standard response is to create more judges, to create more fast-track courts, but this has not really addressed the problem. Would you say, sir, that one repeated suggestion was to extend the retirement age from 62 to 65 for High Court judges? Would you say that that is a good suggestion? I wanted to put this controversial question to you, sir, to Justice Lahoti.
In my opinion, yes. Not only yes, it is a must. If we increase the age of retirement for the judges of the High Court, it will serve two purposes. First, we will have an active judge, active experienced judge at the prime of his maturity, a mature judge, to dispense just continue to dispense justice. Yesterday, during the discussion, I told him that 15 years after my retirement, I can work as an arbitrator, record evidence, hear arguments, prolong arguments, and construct my awards. Why I cannot act as a judge? So that's the question. The age of retirement must increase for all, but it must be uniform for the judges of the High Court and the Supreme Court. The second and more important thing is, if the age of retirement is the same for the judges of the High Court and the Supreme Court, a lot of rat race would stop, and the dignity of the office of the Chief Justice of the High Court would be restored, which is eroding day by day. Third, now that's all. There's two things about the age of retirement.
You have really mentioned some very strong comments you have made, sir. May I request Justice Srikrishna to give his thoughts on this issue of, because there has been a proposal from time to time that make the High Court judges from 62 to 65. Everybody has got good health now today, unlike the earlier days. What is your view, Justice Srikrishna? And then
what Brother Lahoti said. Yes, my experience, I have noticed both at the bar and as a judge of the High Court and even as a judge of the Supreme Court is, most of the Chief Justices, whichever place they are in, are always turned toward the north. Now, hoping that someday they will land up in the court. Now, their judgments get colored by what the Supreme Court will say. Now, this is total erosion of the judicial independence. Now, as a judge, you decide what your judicial conscience tells you. If the Supreme Court says you are wrong, that's all. You leave it at that. But then to always try and please somebody in the Supreme Court is absurd according. And that is what is really oppressive. And because ultimately you have your 3 more years that you get in the judicial career, that is not going to make much difference. In fact, this suggestion will make a High Court judge feel that he is independent. In fact, if you remember, one of the Calcutta High Court judges had retorted to the Supreme Court a remark saying the Calcutta High Court does it again, and he pointed out and said, the High Court is as much a constitutional court as the Supreme Court and not a subordinate court. Now, unfortunately, this feeling is gone because of this kind of disparities. And I totally agree with this.
Honorable Justice Venkatachaliah, would you like to say a few words on the 62 to 65? You've been a Chief Justice almost 30 years ago. So would you still say that it's time to make it from 62 to 65?
Two eminent judges have spoken. And I think it's a matter of great satisfaction that this is the view I expressed in the first meeting of the Chief Justices Conference in 1993. He said all the judges must retire at the same age, but not 65, but 68. When you can't get judges. Somebody mentioned what Chief Justice mentioned what President Kalam Sahab said. Kalam Sahab was, he and I, before he became president, worked in the same building for 2 years. I was in the first floor, he was in the second floor. He was the advisor to the Prime Minister. I was chairman of the Constitutional Review Commission. Every weekend we would meet. And I may reveal that one chapter on science and technology, future of science and technology in India in our report was by the inspiration of that man's mind. See, what I say is, these things are absolutely necessary. Why do you retire judges at 62? In those days, the age of the lifespan of a human being in India was 27 years. It is 67 years now. And some of the judges are well-kept, well-disciplined people. They live long. My own example, I live longer than I deserve. And sometimes I think that judges, we are honored, all of us are honored by the presence of the Chief Justice of India. This is a matter of serious implication that that just both Supreme Court and High Court just the atmosphere in the that all these Chief Justices of the High Courts must be treated as the exceptional judges of the Supreme Court. And the Chief Justice of India will be at liberty to request one sitting judge of the Supreme Court to go and work as Chief Justice of the High Court and ask a High Court judge to come and work for a term or whatever terms the Chief Justice thinks to sit in the Supreme Court. I mean, these are all perhaps very ideal situations, may not be practicable in implementing it. There is no hazard. But simple thing is, as two learned judges of the Supreme Court have said, 65 years. In fact, I went to four eminent lawyers of this country, requesting them to accept judgeship of the Supreme Court. I went to Dipankar Gupta's house. I went to Anjar Ujjwala's place in Mumbai. I went to who's that? Justice Satul's son, Atul Satulwal. Iqbal Chagla. Of course, they would have been Chief Justice. All of them declined. Then I declared that you have lost your right to criticize the Supreme Court anymore. In my time, if Arvind Datar was around, I would have caught him.
Yes, Justice Srikrishna, I wanted to say something.
I wanted to say this in connection with what Justice Venkatachaliah is saying. Provision, look, we are all oppressed about the arrears in Bombay High Court or Calcutta High Court or Madras High Court or any of the High Courts. Now, I'll give you my experience. When I was about to retire, the then Chief Justice of India asked me and said, will you work in the Supreme Court for 2 years as additional judge? I'm recommending your name. I declined because of my personal reasons. I wanted to come back to Bombay. I made a counter offer and said, you appoint me an additional judge in the Bombay High Court. I'm prepared to sit there. I don't want to do arbitration. I'll be able to do whatever I did. And there is no branch of law that I have not done as a judge. But then the Chief Justice said, brother, you will become the junior most. I said, what does it matter? I'm interested in doing work. I'm fit. And as the Justice Lahoti said, I am also 80. Now, 15 years I've spent, the best of my life I have given to the private parties for, as they say, for a handful of silver. Now, I could have done this to the institution from where I came out. I could have done to the High Court. If I had sat in the High Court, there was nobody in the High Court who did not know me. And they would have given me equal respect whether I was the junior most or not. I don't know why this is. In fact, I remember when I was a lawyer, 3-4 of these most senior lawyers like Falina Riman, Soli Sorabji, and 2 others, I don't remember who they were. They had offered to work as ad hoc judges in the City Civil Court in order to control this. But then people didn't accept. These are good suggestions that somebody must do this radical thinking, otherwise we are not going to solve the problem. You increase the number of judges, there is the law of diminishing returns, it applies equally to judges also.
Thank you so much. Thank you, Justice Venkatachaliah. As you mentioned, your age of 94 is definitely, we are really blessed to have you. And I'm sure that, that the next book of Justice Raveendran also will be released in your presence, and Justice RAMANA will be there. All of us also will be there. That's my sincere prayer. Now, sir, this is as far as the increase in age is concerned, this will require a constitutional amendment. Recently, we had this judgment of Lok Prahari where they recommended. Justice Lahoti wanted to say something, please.
No, only half a minute.
No, please.
If the age of retirement for the judges of the High Court and Supreme Court becomes the same, the horse increase, I can assure you the Chief Justices would stop taking rounds of Delhi, and you will have the option of choosing the best, dehorse the seniority, and you have to persuade them to come to Supreme Court. This I am telling you with confidence from my experience. Choose the best and persuade him to come to Supreme Court. He will not be willing to come to Supreme Court. He will have to be persuaded to come to Supreme Court. That's what it should be.
Yes. So one suggestion is to make High Court judges up to 65. The other, just Venkatachaliah said, that everybody retire at 68, keeping in mind the energy of all of us that we have at 65 and 68 and so on. That's very good. Now, I only wanted, since all of you have been Chief Justice of the High Court, you've been in the Supreme Court, what is your view on implementing 224A? When we did this Lok Prairie case, only 4 instances where additional judges were appointed. At Madras High Court were 2 cases, in Madhya Pradesh there was 1, but 224 has still not been activated as such. Any reasons in your term as to why this was not done? Can Justice Srikrishna or Lahoti throw
12 o'clock.
I made an offer, my offer was not accepted, so I came back here. And here I am spending my time doing a lot of arbitration, helping somebody other and making a lot of money in the bargain, which I could have used. At the same time, I would have utilized for doing work in the High Court for whatever last round salary was.
Yes. You're muted, sir.
See, this 224A is a fantastic idea. And I would a little modify it, borrowing from Honorable Justice Venkatachaliah. 224A should be utilized in such a way that instead of calling on the retired judges, the consent of the sitting judge should be taken. Those deserving good judges who have worked very fast and knowledgeable, that they will continue to act as additional judges of the court until the vacancy has been filled up. This is one point. Second, for 224A also, the appointment shall have to be done by the president. Now, if we can persuade the president, the government, the executive, to make appointments under 224A, then why not the new appointments? I would suggest that the Honorable Chief Justice of India would kindly consider it. The honorable judges and the CJI are reluctant to talk to executive. What is wrong in the 2 constitutional functionaries having a dialogue from time to time? From newspapers, I learned that 50% vacancies are lying in the High Courts, and many recommendations made by Supreme Court are hanging fire at the end of the government. Why should not the 2 constitutional functionaries have a dialogue and sort out the issues? Why correspondence? So this is my request. 224 is a good idea, but the way Honorable Justice Venkatachaliah puts it, it's a much better idea. And I would suggest that the new recommendations which are pending for a long time must be sorted out by a dialogue, not by just writing letters.
So I think the net conclusion is that as a judge, High Court just retires at 62. He continues under 224A for some more time till the vacancies are filled up. That is the suggestion that is made, because even in the Lok Prairie Union of India Bar gave a very positive affidavit and said yes for people who are retired. And the idea was to select judges in their specialization. Suppose in a particular court, more criminal cases are pending, then retired judges who are specializing in the criminal area can be asked to continue. Yes. So now can we just move on to the next topic which I suggested was, which is bothering all of us, is technology and law. Now, I remember coming back in March for the holy holidays to Chennai. I never imagined that I would be stuck in one city for 15 days but fortunately, thanks to Zoom hearings, virtual hearings, we have been now used to a new method of working. I think all of you are conducting arbitrations from all over the country and the world from your respective houses and chambers. I just wanted to know, as far as technology and law is concerned, would you recommend that some kind of a hybrid system to continue? Because I don't see this going away. And even assuming the pandemic goes away and we come back to normal, will it not be would you suggest that we have a continued hybrid system, say 3 days of virtual and 2 days of physical? What would you recommend? I would ask just Venkatachaliah have been at the forefront of recommending technology. You have recommended Six Sigma and so on. So I would request you to mention about the new method of virtual hearing. Although there are classical purists who say that there should be a physical hearing that makes.
I would, if I recall, in the Law Quarterly Review, there's an article by an American senior lawyer. I think you kindly trace it. The title of that article is Gentlemen, Their Lordships. The title is Gentlemen, Their Lordships. The theme is how appeals are argued on either side of the Atlantic. Sir Raymond Evershed Committee had members of Supreme Court judges, the American Supreme Court judges and the House of Lords members. They went into the question of hearing, and this article by a senior lawyer from America, Gentlemen, Their Lordship, that's how judges are announced into the room. He said the essential morality of the process in common law system has to be maintained, and to the extent technology will promote it, to the extent it can, for example, if it becomes impersonal, you see, for example, cross-examining a eyewitness in the court, it can't be done online. This part of the work must be, there is the personal, the morality of the process and the impression, emotions, things like that. Of course, technology may develop itself into a state where it's amenable to such kind of use also. You can see the person in 3 dimension, photographically, and things like that. And things it will happen sooner than you think it's possible.
Yes.
Gentlemen, I'll tell you, within the shortest possible time, the leap of technology will be such that we don't know where we land. And you must take care that the essential feature of a common law system is the morality of the process. That's what that article said, that the American lawyer said. I found myself unable to equal myself to the great art of personal presentation than a written brief. And I think he said this: 100 pages of closely typed written argument may not sometimes be sufficient to a shrug of shoulders of the Queen's Counsel in the court. See the way in which the communication is done. To the extent it can be maintained, well, it's good. But you see, the limitations and the emotional communication quotient in technology must be recognized, and to the extent it will not affect that, it can be utilized. Of course, a time will come when it will be more than personal hearing. You can see the man in 3 dimensions. 3 dimensions. All the judges come in all sizes and shapes, and their works are all seen in the public. That stage will not fall. And the capacity of India to assimilate technology is very high. See medical technology, dentistry, ophthalmology. New technologies occur in America, and within 3 months it's in Bombay. The degree of somebody was explaining, a man was running a bullock cart, and suddenly he stopped before a booth for cashing his credit card, and went into the booth and took money and came back and continued in the bullock cart. This is the kind of degree of absorption of technology. These are all very, very interesting questions. But theoretically, yes. To what extent it will depend on the experience of lawyers and judges. I don't think it can be, as a present technology that we use, a personal appearance before a judge, the effect of it is totally different from what you address remotely through online. But I told you yesterday that I would confine myself to your point 1 and point 3 in the overlapping areas of that.
Yes, please, if you can elaborate on that.
Yes, of that. I'll only take a few minutes to present
Please.
that point of view. That will also involve, you see, technology yesterday is different from technology today. Justice Srikrishna dealt with that. There is a seminar in which last year, I think 2 years ago in Bangalore, for artificial intelligence. What is this machine intelligence will do? You leave your telephone at home, your mobile at home, have a dinner in a restaurant, and have a
Voices.
dish there. How was the dish? The kind of data that gets into the thing is a very, very, very difficult thing to imagine how it will take shape. And it can, voter preference can be monitored. Voter choice can be predetermined. It can influence the whole course of our life. And that's the Supreme Court. I very briefly tell you my ideas of how you can discipline the trial system. These suggestions which I am making are not for implementation at all.
Sorry, sir, we have lost you, sir. I think we have lost you, Sir Venkatachaliah.
They are to be put to the fire of, the story used to be said that an old woman had surplus supply of betel leaves every day. She would eat over 10 or 20, but she would put all the fresh stock underneath the present stock. And continuously he was eating only the stale ones.
Got it. So we can't. So we can't.
Because the person, but only to have the feasibility, economic viability, and the tenability determined by an expert group.
We have lost Justice Venkatachaliah for.
With specialist systems.
I think I just. We can't hear Justice Venkatachaliah. Sorry. Yes, sir. Sir, you're muted, sir.
You're on mute.
Yes, please, sir.
Am I audible?
Yes, now, sir. We lost you for a couple of minutes, sir.
And this is only to be put before an expert group of judges, experienced judges, lawyers, and systems men. It is generally said law is too important a matter to be left alone to lawyers and judges. Today it is very, very significant that the systems are not merely computer men, it is the systems men. And you see, there is some organization. There used to be one gentleman, Mr. Srikrishna will know. Perhaps he must have, that gentleman must have troubled Mr. Srikrishna also. Well, there's one Mr. Bhagwan Das Rayani in Bombay. He used to call it Society for Fast Track Justice. And there is one group called Daksh in Bangalore. They have done enormous work on this area. Crucial idea is when the banks went back, perhaps it had started in Italy. When banks had the problems, they had a good bank and a bad bank. I would not use those good and bad words. It's a new bank and the old bank. The new bank is to carry on the current business correctly, and the old bank to handle the problems of the inherited problems. What you want is the new court on and after a particular date. Try it as a pilot project in one district. In the 50% of our work in the high courts and the trial courts are in 5 states. 5 states. In the trial court, 70% of the work is criminal work. Trial state, 30% is civil work. There's a dramatic reversal of the proportion when it comes to the high court, where 70% is civil work and 30% is criminal work. That itself is an indication what is happening in the trial court. Crucial idea is to have a new court on and after a particular cutoff date. The fresh cases are filed in the new court on an assembly line basis. And that assembly line will say which court, which case, which type of case requires faster treatment. For example, a matrimonial matter, where if you make it more than 6 months, there'll be nothing left in the marriage at all. Custody of children. You remember a letter, barrister to the Lord Eldon. Everybody knows that story.
Yes.
This minor was came to your court in your busy schedule. You would not. Now he has attained majority. Therefore, you don't take the trouble of pronouncing the judgment. There's the old notorious story of law delay. You put this into the system, and that will say the adjustments in the main case are not given by the judge presiding officer. It is by the man systems controller who will have the meeting with the parties on both sides, fix a schedule for that case. If you file it today in October first week, you will get ready for this thing, and systems men will provide it to the computer a slot for it. They will assess the man hours requirement, time requirement, and make it 3 times that, so that to accommodate possible lapses in complying with this thing. And the systems man will provide you all that. Supposing you are not able to do it in the month of October, so he gives you a slot in alternate now in advance. After the issues have struck, the conference, and both the lawyers will decide how the case should proceed, and give alternatives in the case of their non-compliance. And this is done by the controller of the system. The judge will only deal with interlocutory give dates only for interlocutory matters and urgent matters, interim matters. The main matter is under the control of the system. This is and put it in one district in one state under the supervision of the chief justice of that state and the judge who is familiar with this thing and some systems expert. Try it. Just give it a trial, and you will produce enormous results. In fact, this is exactly what I told Arvind Datar's group when he invited me some 20 years ago to inaugurate his Palkiwala Center. There I said, under the captain Six Sigma in judicial proceeding, I dealt with that, and that was published by the National Judicial Academy. And then system should declare what kind of cases should have time limit. Custody of children 6 months, divorce matter 6 months, whatever the time you think the systems will say, the lawyers will say, the judiciary will say. And I think, and then ultimately, a case put on the assembly line, fix an ultimate thing. 2 years is the maximum period for the pendency of that matter, depending on the logistical support that you have from the judiciary, or 3 years, but no case should spill over that period. Though other cases could be disposed of. This is possible.
Yes.
In Suffolk County, Lord Chancellor outsourced the case flow management experts. Some experts, and those 2 experts, I invited them to Bangalore. They had come here. They had an interaction with the State Judicial Academy. This must be, you put the Judicial Academy to ultimate, ultimate resources and let them work it out and give. This is only a recommendation.
Yes.
If an expert don't implement it without trial and test it, tensile strength should be tested by experts who discuss it, point out the lacunae, and then at least know what is possible. Then movement and progress of the cases are under the overall systems control. Only interim and interlocutory proceedings and hearings and adjournments are under the presiding officer. At the completion of the proceedings, the cases go into a loop line for mediation. We'll have to have trained mediators. If the parties agree upon a mediator, they must say in the pleading itself, in the format, that we are agreeable to so and so. The trained mediator, the lawyer, or the judge, even a serving judge as a mediator in the matter. You have, say, 2 months. Ultimately, overall time limit for each category of cases can be maintained. It's a very strict thing. Legal staff have to be intensely trained. Lawyers have to be trained. Junior lawyers have to be trained. It is an immense problem. It's not an easy thing. But if you don't do it, you won't survive.
Thank
There
you.
is, I told in some state, a criminal appeal bench for 20 years. Can you imagine a criminal appeal pending for 20 years?
Yes, sir. We can definitely.
Next, after completion of the proceeding, the cases go into a loop line for mediation. A list of qualified mediators will be maintained, and this mediation is going to be a very, very powerful instrument. The system inspires confidence. A lot of things can be done by that. Time schedule for entire career suit is fixed by the systems administrator in a meeting between the parties and the lawyer. And they decide this is the kind of time man hours that you require for your witnesses. And secondly, outsource 30% of judicial work to lawyers as commissioners. They'll record evidence for you and give it to you. And lawyers will say which witness will be evidence will be recorded by the commissioner, which requires oral cross-examination in court. And this will have to be decided amongst lawyers. They must develop a culture. Lawyers must develop a culture of justice, not merely as contenders of opposite parties. Then 30% of the judicial work is to be outsourced. 30% of the judicial work is to be online. Filing of a written statement, objection to this thing. All this could be online, it will not come. The point I wish to make is the loss of man hours, loss of productivity, attributable to unaccounted for adjournments. Parties going to court, lawyers going to court, coming back. Well, 18,000 courts, 22,000 courts in the country. People go there, come back. The loss of man hours and loss of productivity. Somebody has estimated 150,000 crores. 150,000 crores if you estimate it at 300 rupees per head per day. Because the accuracy of that is to be verified. You see, a part of it is spent for the welfare of lawyers. You see, lawyers can be reasonable if it is suitable to them. Without the active participation of the legal community, you can do nothing.
Yes.
In the adversarial system, well, this is the most important kind of thing. And you have to try these things, don't put it into practice unless it's
Yes. No, I agree, sir. We should first try it as a pilot project in 1 or 2 districts. And then...
Even before a pilot project is done, have an expert people to assess. It may raise some cynical eyebrows. Well, it's not possible with the kind of culture that lawyers have in the country or judges have in the country. There may be so many reasons they'll point out. All that I wish to appeal to the judicial community is give it a try, because
Yes.
all of the things we have tried is gone.
Yes.
We did the fast track courts, it didn't work. We had that saying so many statistics, so many reports, and then we are trial work is, for example, if it's a tenancy agreement, it's an unprotected tenancy, and tenancy is admitted. When a suit is filed, you must have a system by which you have a decree nisi and show cause why it should be made and not be made absolute. And a mortgage debt. Where is the question of going through all this kind of thing? If the mortgage bond is there, privacy, the time has expired and the suit for either sale of security or foreclosure. Initially, you make out a case for a decree nisi and you should not be made absolute.
Yes.
These are procedural things which require serious consideration. Otherwise, you can't handle it. You can't handle it. Everybody will throw up his hands and nothing can be done. And thirdly, massive training program for legal, paralegal, and court officials for working out the system must be undertaken by the National Judicial Academy. It is not that everybody should go to Bhopal. National Judicial Academy can interaction with the state academies all over the country, and that you should In fact, that's the complaint that was made against me, that I chose Bhopal. I chose Bangalore first and requested one of my colleagues, judges, to come and inspect the place. And the way he was driving, the revenue secretary was in the car. He said, "Sir, this land has already been given to somebody else." And I think there's some confusion. The chief minister is not aware that there is some already. What you are inheriting is not land, but litigation. He didn't even go to the place. He turned the car back and came and said, "Don't touch them with a batchpole." And all the time, the chief minister of Madhya Pradesh was sitting next to in our room. He offered 120 acres of land, 60 acres and 60 acres another the buffer forest. And then see, and he also showed that there are at least about 1,000 flights every week are between Chennai to Delhi, Hyderabad to Delhi, Cochin to Delhi, Bangalore to Delhi. He said if only 1% of them are hopping flights, the connectivity would improve. Bhopal is geographically the heart of the center of this thing. But it was unfortunate that the connectivity was not very convenient. So, but it's a 5-star facility. We fought a battle with, and the Prime Minister was so helpful that almost 100 crores was spent on that. Make full utilization of it, make that the center, not that everybody should go to Bhopal. They can come to Delhi, they can come to any part of this country, and it is under the umbrella and the aegis of that institution that you should work. And I appeal to the Chief Justice of India to revitalize that institution and push it to its potential, achieve its potential. And it's a great institution. Once Mr. Lahoti, Chief Justice, invited me to head that institution. I told him I have left the judiciary, I have entered that building again. So I thanked him. He may recall what he once told me, that it has, in fact, one American Supreme Court judge said that the best campus anywhere in the world.
Yes, it's undoubtedly
the finest
beautiful
campus anywhere in the world. Even in Reno, which I have visited, is not comparable to Bhopal Academy. You push it, put them into test and let them come out with this kind of thing. And then another 30% of the judicial work must be online. So 60% of judicial work must be online, and another 40% or 30%, which is essential work, the orality of the process, that must be recognized. Is my submission to you. And then, you see, there is one technical issue. I've made a study of that when I was in the High Court. What time in the life of a litigation is consumed by bringing LRs and record? The delay in courts is such that one or the other party will die. You can assume that. And tracing the legal representatives and record, thanks to the delays of the system, parties will live their normal life and exit. The bringing them record, they must trace them, find out, serve them, it's impossible. Please consider this idea.
Yes.
A plaintiff, he will say, in the event of my death, so-and-so will represent my estate. He is my nominee. There's an insurance policy. He says, my nominee, he will continue the litigation. He will continue the litigation. The LRs can come on record on their own, but it's not necessary for the man to search for the progeny of the man and then trace them and get. And it's a terrible thing. I've been a trial lawyer myself. I know what it is to bring a legal representation record. Please have a nominee system. The advocate must say, I will appear in the event of the party's death, I will appear for them. It's optional for the LRs to come on record. This is a very convenient thing. And secondly, see, many of the actions, mortgage suits, admitted landlord tenancy, you have a proceeding for making a decree in ISI and say, ask them to show cause why it should not be made absolute. Otherwise, not a eviction proceeding where a protected tenant is an ejection action in law. It will take 10 years. I don't know at that rate what will be the nature of confidence people have in the system. We still believe that people still have faith in our system. And that is the problem which is coming in the way of reform.
I think what we can do is, what your suggestions we can tabulate and give it to my Lord the Chief Justice, and we'll see what we can best do as a pilot project. We can definitely.
No, but one thing, see, the number of kind of actions, for example, a promissory note, a negotiable instrument, the sanctity of a presumption of the negotiable instrument act, a promissory note. Well, you see why a decree in IC is made, why should it not be made absolute? If you give it, it will focus the right focus on the right element in the litigation. Every litigation need not have this kind of full adversarial scope. And every adversarial system has inquisitorial elements in it. There are some, I mean, I am not saying that these are the exhaustive candidates. To explore this thing, just have an expert committee with systems, not lawyers. Lawyers, of course, you must take, and you must put something into their pocket also by way of additional income. Otherwise, nobody will do charity for the sake of litigants.
Yes.
Some of the things which have to.
Thank you. Thank you.
Thank you. And so technology is concerned. It is going to be tomorrow, if not today. It will be leaps and bounds.
Yes.
And see, you can have Chief Justice RAMANA, and he may sit in his own place, but his three-dimensional figure will all come. In fact, this will come up here like the rishis that were descending from the heavens and to the earth. And I think in the last election, somebody tried it also.
Yes, hologram.
Tried it also. The holographic three-dimensional figure. Now the science of haptics has made it possible to shake hands with them.
Yes.
Shake hands with them. And robotic surgeries, a surgeon sitting in a console in New York conducts an operation on a patient on the surgical table in Paris.
Yes. So we definitely
done.
We'll definitely implement. Just as Lahoti was mentioning about this virtual. Oh, sorry.
I think we have taken undue advantage of the presence of the Chief Justice of India to keep a lot of. You see, people say, if you keep your mind too open. People say if you keep your mind too open, people put a lot of rubbish into it.
and just Venkatachaliah said
it may be something.
So I don't know, after the courts reopen, we'll see all the chief justices and judges in 3 dimensions. I don't know. But apart from the lighter vein, what I wanted to ask Mr. Lahoti was now this for the immediate problem is the Zoom hearings, the WebEx hearings, the virtual hearings. I spoke to a lot of people around, and I find that there is a lot of difficulty in connectivity in the district courts and subordinate courts. High courts and Supreme Courts are working well. We are all used to it. What is your view? How do you sort out this issue of virtual hearings in the
Microsoft is donating the systems to education institutions. We won't see them.
We'll do that, sir.
Government's communication systems. I mean, I'm not blaming anybody. There is security element, the cost element. There is so many other elements in the thing. You can't simply generalize and say National Informatics Center, the one who pursued them. The first access to case data was initiated by me in the first week of my taking charge in '93. And I inaugurated that console in Bangalore, where on a fee of 10 rupees, you can get the statistics of your case anywhere in the country. Now it is just a difficult tips.
Lahoti, you wanted to say about this virtual courts?
Of course, Lahoti Saab, you are at liberty to criticize me. This idea.
Sir, kindly excuse me, folded hands. You see the advantage of virtual hearing. In physical hearing, you could have been stopped. In virtual hearing, you cannot be stopped. Sir, I can't afford to criticize you, sir. I follow every word what you say. Sir, your word is your final dicta. Mr. Datar, I have only 2 points to say.
Yes,
Very
yes.
in 2 minutes.
Yes.
Number one, you can't stop the flow of the event, of the wave, the time for which has come.
True, true.
Now it's day of modern technology. You can't resist it. You must adopt it, and you must flow with the wind. 1, 2. Technology has got so many advantages.
May I say one thing there?
Sir,
It is Victor Hugo said, no army can stop an idea whose time has come.
True.
yes, sir, that's right, sir.
Stop
Sir,
an
I
idea whose
couldn't.
time has come.
Sir, that's right, sir. That was Victor Hugo. I couldn't quote it fully. Right, sir? Victor Hugo. Sir, the second point is,
Yes.
we need not be at all apprehensive. I can vouchsafe it. I think Brother Justice Raveendran, Justice Brother Srikrishna will vouchsafe it. For 17th March 2020 was the last hearing which I held, physical hearing. Ever since then, for last 14 months, my 100% hearings in arbitration are online. Most complicated issues, ONGC, underwater disputes, port disputes, dredging, building the port, airline disputes, courier disputes, all these disputes, BHL disputes, involving highly sophisticated questions relating to technology, where the drawings are 1 meter by 1 meter. And we are examining. I have recorded all evidence online.
So
I
you
have
cross-examination
heard
also online, sir? Will
cross-examination online. And arguments extending over 15-20 days, all online, without any difficulty, and awards pronounced. It is not at all difficult. If there are any difficulty, they can be solved. India is a vast country. The problem of connectivity can be solved. The commercial operators will be coming gladly in forefront and ahead to join hands with the judiciary and to provide the services where they can reach the farthest corners and can provide services. 2. Third, not only 3 dimension, now 4 dimension, 5 dimension is coming up. So, so far as Honorable Justice Venkatachaliah said that 15 pages of arguments will not match one shrug of shoulders. Now the shrug of shoulders can be virtually seen. All the expressions on the faces can be read. So it is not at all difficult. This I am telling you from my own personal experience. And Lucy, see one more thing. How much cost effective it is. In all those matters in which I am holding virtual hearing, some PSUs have issued circulars saying that they prefer online hearing. Every online hearing saves at least 5 lakhs rupees per day to each of the parties. Online hearing is highly cost effective and time saving. If I have to participate in an arbitral hearing at some place, I have to leave my place at 1.5 hours in advance and reach that place, local. Now I come just 5 minutes before, join the hearing, finish the hearing and leave in 5 minutes. It saves time, saves cost, and is equally effective. This can be done in the courts also without any difficulty. Only thing is, we shall have to get used to it. This is all my observation, but I wanted to say.
Srikrishna, you would like to say something?
Yeah, I agree. In fact, I am a votary of this. Of course, for a man like Justice Lahoti, it's easy. I am a little computer illiterate, so I will find it a little difficult. The point is, in the courts, all judges are not equally capable of work on computers. All staff is not equally compatible. All lawyers are not. Therefore, till people get used to it, you should continue the hybrid process, not in the manner that you suggested, Arvind, not 2 days. You make it obvious to me. I am a lawyer. I want to conduct the case. Are you comfortable with this? Go on online. If you want to do it physically, I'll do it physically. So we have these both systems running parallelly. Until one time they can be merged and then can be made completely virtually. Now, I don't keep much talk about this witness's expression not visible and all that, that we know how much of trial court does really does that. I mean, our trial judges don't really bother about the witness and the
demeanor of the witness.
it's all theory, yes. In practice, we don't find it at all. All of us have been lawyers, all of us have been judges and the High Court Chief Justice and Supreme Court judges. Now, therefore, and particularly, all this is irrelevant when you are dealing with the High Court or the Supreme Court. You are not concerned with witnesses. You are concerned with lawyers, their facial expressions and the judge's facial expressions, which are easily visible on the, I mean, if I'm arguing before a judge and I find that his face tells me that I'm not cutting guys, I'll cut short. But that is very visible on speaker and I can see in the expanded view of your face. So, but only thing is this, till people get used to it at all levels, continue the process simultaneously. Otherwise, there will be infinite chaos.
So I take it that your views are that since all of you have spent all your judicial life in physical hearing and now we've gone to the virtual age, you say that virtual should eventually be the rule and physical should be exception, maybe in batch cases. Or...
It is like saying which language should be there. Therefore, English has continued with Hindi simultaneously continuing. Someday we'll switch over, but let it continue till people get used to it.
Thank you so much. In fact, we wanted to have one session on PIL, but we're running out of time. We already.
Mr. Datar,
Yes,
just
yes,
I want to give
please,
you
sir, please.
nothing. Just I want to, for the sake of clearing and giving information, my Secretary General has furnished this information.
Yes, sir.
After this pandemic, we have worked 287 days hearing, almost average of 11 benches, and taken up the matters, different matters, and the total matters which we have disposed of so far in these 287 days hearing, including hearing, is 92,312 hearings has taken place, and the disposal is already have published in the website. Apart from that, we have I interacted with all the Chief Justices of High Court recently, 2 days continuously, and by virtual mode only. In the meetings, all the Chief Justice have suggested, requested 2-3 things. One is about vaccination of the lawyers, judges, and their families, and the court staff. Second thing is that some assistance to the junior councils and all that. Third is the most important thing is this connectivity issue, particularly in the rural areas and
Yes, yes.
So immediately I thought of initially calling these companies, telecom companies, and request them to provide, boost the systems, particularly in rural areas and hill areas, and providing some centers exclusively to provide facility to the rural lawyers to address the courts. But instead of my taking up that thing, I thought that I requested the minister, law minister, telecommunication, Mr. Ravi Shankar Prasad, to call these players, that particularly the telecom companies and the corporate social responsibility are aware. They can provide in some taluk centers and district centers some facility. So lawyers can come there and they can use this system, particularly uninterrupted internet, to address the courts. This request I have made. Let me hope that they will take up the matter. And otherwise, I will take up some request the companies once again myself.
Yes.
This is for the information.
Thank you so much. And in fact, there's one thing that what is the next thing is the digital divide. Those who have access to digital facilities, those who don't have access to digital.
That is the major issue.
It's going to be the main issue. A very good lecture by Mr. Farid Zakaria. He says now the problem is not the have and have-nots. Those who have access to digital and those who don't have access. That is going to be the.
I suggest. I told the very same thing. Now, if you don't take care of these lawyers who doesn't have this facility of the technology, you are one generation lawyers of the rural areas will be out of the system because they can't afford. They are not getting briefs. They are not getting money. In addition to that, they don't have the advantage of the technology. So you are completely taking out of these lawyers from the stream, which is very dangerous.
Yes.
This is the main concern of me.
Yes, yes, sir. They're very serious. I think I'll have to stop now, and now I'll request the star of the day's function, Justice Raveendran, whose book we have all. In fact, this lot of topics are worth debating, but since we're running out of time, I would now request Justice Raveendran to give us a few remarks about his book, about today's function, and what he thinks should be the road ahead.
Thank you.
Mr. Raveendran, could you please?
Yeah, thank you. I want to share two thoughts about the two subjects that were mentioned before reading formally what I have written as my response. The first is elaborate discussions were held about the age of retirement of High Court judges and Supreme Court judges. I totally agree that it should be the same. It should be 65 or it can be 68. But the experience, the benefit of experience, which is available by extending the age of retirement, should not be restricted or limited only to the Supreme Court judges and High Court judges, but it should be extended to the subordinate judiciary also, in the sense, you see, we have 35 Supreme Court judges and 1,080 High Court judges. We have 22,000 subordinate judges who also gain lot of experience by having worked for 20 years or 25 years. Why at the when they are at their zenith, why send them away at 58 or 60? Why not make it 62? It need not be the same as the Supreme Court judges or High Court judges. But when we are considering or talking of increasing the age of retirement of the higher judiciary, we should also consider a corresponding increase in the age of retirement of subordinate judiciary, which will also make it more attractive for persons to join the subordinated judiciary. This is one point I want to say about the delay aspect. In regard to technology, I fully agree, and I respectfully agree that, you see, we cannot stop the digitization, and the more and more virtual hearings will take place. Of course, the best is first restrict it to the Supreme Court and High Court, see how it functions, remove all the glitches and bugs, and once the system has stabilized, then slowly take it to the trial courts, that is the district judiciary. But I want to flag one human issue which is causing a lot of heartburn, which also should simultaneously be considered. What is that? See, the distance till now, it was all physical. Because it was physical, we had a Supreme Court bar, we had a High Court bar. If it is a tribunal of company law, there was a company law tribunal bar. If there was a telecom tribunal, there was a telecom tribunal bar, High Court bar, district bar, magistrates court bar, specialized bars. Now, because of this digitization, because of these virtual hearings, the Supreme Court lawyers are arguing before all the high courts, and the High Court lawyers are arguing before the district courts. This has led to some kind of apprehension in the mind of the lower rung lawyers that their bread and butter is being taken away. It is, you see, for an argument, it can also be said it has opened up for a district court lawyer to straight away argue in the High Court or Supreme Court. That is also positive. That is the positive side. But that has not happened. They are afraid, and it is while discussing and debating the virtual hearing, we should also take note of the apprehensions of a large number of bar, and we should provide some provision should be made. Otherwise, you see that there will be discontent and there may be some kind of inconvenience to majority members of the bar. And the Honorable Chief Justice was mentioning about how in taluka places and other places, the one entire generation will miss the bus. So let us, there is a need to take all. It is not sufficient if one section is served or one section is provided. While virtual hearing is there to stay, let us do it in a manner that it does not affect the larger section of the members of the bar. This is my request for as far as the second subject is concerned. Now, let me formally move to my response. Honorable Justice N.V. Ramana, the Honorable Chief Justice of India, Revered Justice Venkatachaliah ji, Bhishma Pitapa, respected Justice Lahoti, respected Justice Srikrishna, eminent jurist and senior advocate Mr. Datar, Mr. Surendra Malik, Mr. Sumit Malik, and the team consisting of Ms. Batija and Mr. Indulia, and my friends who are participating in this webinar. I thank the Honorable Chief Justice for finding time during his busy schedule to release my book, Anomalies in Law and Justice. I also thank the distinguished panelists and the moderator for sparing their valuable time to join the panel discussions. I feel humbled and honored by the kind words of the Chief Justice and the distinguished panelists. In fact, I detect bias, which in my favor, which should not be there because these are all eminent judges. The articles in this book are based on some lectures on law and justice given by me in the National Judicial Academy and the State Judicial Academies, and some memorial lectures. A constitutional democracy requires institutional safeguards for proper functioning and survival. Judiciary is one of the institutions that play a key role in making democracy and rule of law meaningful and effective. Like all other constitutional institutions, the effectiveness of judiciary as an institution depends upon the persons who control and operate it, as also the trust and confidence they command from the citizens of the country. Such trust and confidence can develop only when the citizens understand the working of the judiciary and appreciate the need for independence, integrity, and impartiality of the judges. Though much is written about the functioning and working of the higher judiciary, very little is written about the problems and issues faced by the subordinate judiciary. As I mentioned some time back, as against 35 judges in the Supreme Court and 1,080 judges in the High Court, there are more than 22,000 judges in the subordinate judiciary. As far as the common man is concerned, they are the face of the judiciary. It is not the Supreme Court or the High Court. Any discussion about delays and access to justice primarily relate to the subordinate judiciary. There is therefore an urgent need to discuss and debate upon their problems, their stressful working conditions, and the safeguards needed to maintain their independence, integrity, and detachment. Some of these aspects are discussed in these articles. In that context, the articles also examine what is required of judges, what is expected of judges, and what is to be delivered by the judges. I would say the object of these articles is to demystify several aspects of law, justice, and judiciary, and to remove some of the misconceptions about the functioning of the judiciary by examining the basic concepts of law and justice and their interplay. These articles also attempt to discuss ways and means of improving the services rendered by the judiciary and strengthening the functioning of parliamentary democracy. I have endeavored to use jargon-free language so that neither a legal background nor a law dictionary is needed to understand the matters dealt with in the book. While drawing attention to some of the problems faced by judges in improving the justice delivery, the article suggests some solutions for some problems by considering what the governments can do, what the Supreme Court can do, what the high courts can do, what the judges themselves can do, what the bar, the media, and litigants can do to improve the system, to improve the justice delivery. The fact that the book discusses the problems regarding the functioning of the judiciary does not mean that judiciary is irretrievably engulfed by those problems. I am not a pessimist like Justice Michael Kirby, who, when asked about the future of the courts, famously responded, "What makes you think that they do have a future?" I firmly believe that the judiciary has a future that to a robust future. It only requires the judges to pull their socks up and show more commitment and concern for the cause of justice. The object of my book is not to criticize, but to make the stakeholders think, debate, and attempt to find solutions to improve the performance of the judiciary so that it can serve the public better with improved credibility. I would humbly adopt what Justice Holmes said about his criticism of law to what I have said about judiciary and judges. I quote, this is what great Justice Holmes said. I trust that no one will understand me to be speaking with disrespect of the law because I criticize it so freely. I venerate the law and especially our system of law, but one may criticize even what one reveres. Law is the business to which my life is devoted, and I should show less than devotion if I did not do what in me lies to improve it. I unquote. I respectfully say, and by adopting the words, that if what I have said hurts anybody, please don't feel hurt, because my intention is not to hurt anyone. It is only to see that the conditions are improved so that judiciary functions as a better institution with better credibility in citizens of India. I thank you. I thank you all. And I thank Mr. Surendra Malik, Mr. Sumit Malik, and their dedicated EBC team for their efforts to bring out this book in a wonderful manner. Thank you all.
Thank you, sir. It's been an absolute pleasure to be a part of this event. I would like to thank everyone who contributed to its success. Many thanks, first of all, to the distinguished panelists, Honorable Chief Justice N.V. Ramana. Thank you so much, sir, for your insightful speech. I would also like to thank Justice Lahoti, Justice Srikrishna ji, and Justice Venkatachaliah ji for the very thought-provoking speeches that were made by them, and also for them taking part in the panel discussion. Next, I would like to thank Shri Arvind Datar for being an excellent moderator and for asking such insightful questions. The entire panel discussion was a treat to the ears and an excellent learning experience for all the attendees. We would like to thank you not just for the discussion, but also for going through the book and for giving your valuable feedback. The production of a work of such a nature cannot be of merely one person. Our thanks goes to the entire team.
Was he lost?
No.
Was
Disconnected.
We lost you, Nilofer.
Mr. Indulia, you can say the last word and complete it in place of Ms. Batija. You can thank everyone.
So yes, in the end, she wanted to conclude that we want to thank our entire team and everyone who has joined with us today and making this launch successful. And congratulations to you. With this, we would like to end the discussion with due permission from everyone.
Thank you. Thank you. Namaskar.